I'm Dru Stevenson. This is for my administrative law class. Here I'm going to be talking about National Tire Dealers and Retreaders Association, Inc. v. Brinegar. This is a case from the D.C. Circuit Court of Appeals. And here we're talking about judicial review of agency rulemaking actions, both on procedural grounds and substantive review. So let's dive in. So I want to give you a quick preview of this case. First of all, this is about judicial review of agency rulemaking under the Administrative Procedure Act, just to get our bearings here, and specifically applying the arbitrary and capricious standard of the APA in Section 706 to this type of agency decision about what rules to make or what to require of the regulated industry. And our key issue here was really specifically a challenge to the federal motor vehicle safety standard concerning retreaded tires. So these are used tires that have new treading put on in a factory or a facility that does that. The challenge regulation in this case was what we would call FMVSS number 117, and specifically S6.3.2, which basically required permanent labeling or embossed on one of the tire sidewalls of a number of specs of the retreaded tire. And so for retreaded tires being sold after February 1st, 1974, the safety agency from the government was requiring that they have all of this information. So I have a diagram or picture here showing you the type of information. You've probably seen tires your whole life and have noticed that there's writing on them, and some of you may not have paid attention to what all of the letters and numbers mean, but now we're going to learn at least enough to understand this case. So as you can see here, there's a number of different things, and these are embossed. Some of them have to be like a part of the rubber wall of the tire. They can't just be painted on or written on the tire. And so things like the tire size, the maximum inflation pressure and load, the actual ply rating, whether it has an inner tube or is tubeless, and whether it's radial or bias and belted construction of the tire. So these are technical terms. You don't have to understand everything about tires. I just wanted to show you this so that you can see that there was a lot of information that the retreaders were going to have on the tire before they got sent out to the retailers. So let's talk about the statutory context here. The statute is the National Traffic and Motor Vehicle Safety Act of 1966, and the purpose was to reduce traffic accidents and fatalities on our roads and highways. The Act's mandates for standards was that they should meet the needs for motor vehicle safety, but also be practicable, or in other words, like kind of feasible for the industry. So the practicability challenge that was brought here as part of this case means we're going to consider economic factors like the reasonableness of the cost and the economic feasibility for the industry. In other words, we can't require something that basically they can't comply with because they would go out of business, that the industry simply can't afford to do it. It's one thing if you're going to have to raise your prices or it might cut into your profits, but if it's the financial burden is going to be basically a death knell for the industry, that might be impracticable. As you might imagine, practicability is often in the eye of the beholder, and that's where the courts come in. So the industry evidence was that most of the existing fire casings lacked permanent labeling or have it where it's already been buffed off during the retreading. In other words, it's not there and they will all have to do it. So let's put this in specific terms if we're going to talk about why is this impracticable. Notice that's a different word than just practical. Practicable means whether it is financially feasible for the industry to comply with the regulation. And so the industry's argument was that the compliant casings would cause a lot of economic dislocation. In other words, they thought this would take a lot of time and would result in about a 2/3 reduction in productivity of the retreader plants or facilities. Also, this is a little bit dangerous. The molding labels themselves are very hot, and there's frequent changes for each tire because every tire needs different information because it has different specs. And so they're going to have to work with hot molding equipment, and it would pose extra safety risks to the workers at the retreading facilities. And they estimated that the cost increase for the consumers would be an additional, like, let's say $2.50, and that's 1974 per retread, which was a 30% increase. And they said it would only be 80% effective. Some of these would wear off over time and so forth. So the court acknowledged that labeling requirements in general do bear a substantial relation to the act's purpose. In other words, the agency wasn't way out of bounds in requiring tire specs for retreaded tires to be affixed as labels on the tires for the information to be given to the consumer. The industry, though, had a proposed alternative, which was that they would have an affixed label, either something that they mounted on it or a sticker, something like that for consumers. So their preference was stickers or paint to give this information that would be on the tire instead of embossed in the rubber. But the regulation required that the labels be embossed, not merely painted, because they said paint wears off when you drive the cars around. So, and the secretary had said that tires get transferred when a car gets scrapped. People take the tires and put it on a different car. The information remains important. The affixed labels last a little longer than the first time the tire is mounted. In other words, even if tires are taken off and that tire gets reused on a different vehicle, the embossed specs and information would still be there. But the court was skeptical and didn't agree with the agency. The court said that permanent labeling, in other words, embossed labeling, was unnecessary to protect the people that are actually buying a retreaded tire from a store. The safety risk that the agency was talking about was only if it was resold from one customer to another and private sales, aftermarket sales. And after the affixed label is gone, and there were no real illustrations to support the safety nexus. They couldn't really say how often this was happening or things like that. They didn't have evidence that consumers were buying things not from retailers, these retreaded tires, with the information worn off. So the court here vacated the permanent labeling requirement for size, pressure, ply rating, type, and construction, but they allowed it to be required for the number of plies and the maximum permissible load. They said that Section 201 of the Act clearly mandated permanent labeling of this specific information. In other words, the enabling statute specifically said that these specs, the ply and permissible maximum load, had to be permanently labeled on the tire. All the other stuff is useful, but that was coming from the agency exercising its discretion. And so it was a harder sell that that needed to be permanent as well. So, what was the remedy in this case since the agency lost on some of the points? Well, they remanded it to the agency for reconsideration. The agency can try to reissue the rule with better support and better explanation for why this is actually necessary. Maybe they were right, the court acknowledges, but the record didn't support the need for this. There's a theory that courts like to get to meddle in agency affairs, and this basically gives the court the final veto power or a check over the agency's rules. There is an issue here that you need to learn in conjunction with this case about the different approach that courts will take if they are reviewing regulations versus statutes, the laws passed by Congress. Even though in terms of enforcement or your legal liability, you could be liable for violating either one. In other words, regulations have the force of law. But when a court is asked to review a regulation, they take a different approach than if they're asked to review a statute that's being challenged. In other words, none of the rules of administrative law apply to the statute or an act of Congress. Courts review agency rules much more strictly than they would the statutory text itself. So even though the statutory text has just as much force of law, in other words, you are just as duty bound to comply with regulations as you are with statutes. When they're challenged in court, the courts are going to be more deferential to Congress than to the agency. Something for students to keep in mind that's ongoing theoretical problem in cases like this. Substance and procedure tend to merge in cases that are challenging the rationality of the rule. And so, in other words, if the party challenging the rule is coming in saying, this is a really bad rule, this is just bad policy, it's not well thought through, they're probably going to raise some procedural arguments and substantive arguments like that this is the wrong rule for the wrong approach for the agency to take. Well, the statutes usually give the agency some discretion. Congress has authorized the agency to sort of fill in the gaps and define terms and apply the statute or figure out how to implement the requirements of the statute. And courts are very comfortable, though, evaluating whether an agency complied with procedural steps and rules. But in practice, there are a lot of things where there's a substantive issue that blurs together with a procedural issue. And then the real big picture or theoretical question is whether this difference between procedure and substance is sometimes just semantic, right? Could the agency have satisfied substantive review with a little more process, or could they have satisfied the procedural requirements if they had a better rule substantively? And that's something to keep in mind when you think about or litigate these rulemaking challenges. So let's talk about how to distinguish this case from the case we studied right before it, the auto parts case. There are some obvious similarities. They involve the same agency, the Department of Transportation. The Department of Transportation in these cases followed very similar procedures in the two rulemakings. And it's the same circuit court, the DC Circuit Court of Appeals from around the same time, and that is purportedly applying the same standard of judicial review. So why did they reach opposite results in these two cases? So the panel of judges was mostly different. Two out of the three were different for these two cases. Judge Robinson was the only member of the DC Court of Appeals who participated in both cases, and he wrote a concurrence in the Brinegar case explaining what he saw as the difference between the two cases. He said that they were different because in this case with the tire retreading, the number of embossed labels, which 6, that the agency was requiring would have been extremely difficult from a technological perspective, at least given the technology of the day, maybe even impossible. And so it would have been too disruptive or might even have crippled the whole tire industry at the time. So the one judge that was on the panels for both of these cases saw the differences being, in some sense, a matter of degree of how burdensome or how much overreach there was from the agency, the same agency, in each case. And that concludes our discussion of National Tire Dealers and Retreaders v. Brinegar. Thank you for watching.